I had a federal bankruptcy case that I was involved in. It was actually my ex-husband's federal bankruptcy case. And I had a good strategy that worked. We said, all we have to do is get the trustee on our side. And another attorney came in for one of the hearings from circuit court, and he didn't have much experience in federal court. And I had been litigating this case against my former husband at the time. And he said, I'm going to go in and make these arguments. I said, no. I said, what we do is we get the trustee to make the arguments because the judge always rules on his side. And I just don't say anything, and I let him do all the talking, and that always works.
Well, Lisa, you got to understand, a trustee in a federal bankruptcy case represents the court. He really doesn't represent the plaintiff or the defendant. He really represents the court. The purpose of the trustee is it saves the court a lot of time and effort in order to bring the facts to the table.
And doing the investigation.
And do the investigation, and also make arrangements if the parties can agree. The trustee can do a lot more than a judge wants to get involved in, and that's to negotiate a settlement. And the best and most important thing a trustee does is to handle the legal issues of a settlement so that the issues do not have to be decided by the court on the basis of the facts in a court case. And the reason I got so many of them, we settled by far the majority of our cases because I convinced the parties always it cost them a hell of a lot more to litigate than it would if they settled. So if we would come to the table and each one would compromise their position, they'd be way ahead. So and that won.
This is an important tip, and I think you'll agree with me. For people who are out there that ever get involved in litigation in federal bankruptcy court, is to be nice to the trustee and get the trustee on your side, and you'll be miles ahead of the game.
Well, that's true. However, the condition I put, both sides have to do that. If one side does it and the other one doesn't, the one who's the nicer one comes out way ahead.
That's right.
So the truth is, if both of them are smart and they want to really resolve the problem, they both work with the trustee and they're amenable to a settlement where no one really is a big winner, but no one also is a big loser.
Right. In my case, the other side wasn't nice to the trustee.
Well, if the trustee is knowledgeable, you got to understand. First of all, I know.
And generally, they all are.
Right, and I know the law.
They're not stupid.
So I have that advantage.
Means.
But more importantly, I was a developer who really understood. This was all real estate involved. I really understood what the problems were. And they were varied and many. And it gave me a step up, and that's why we settled so many. To give you some idea, I was between receiverships and trustees. I handled over 380 cases. That's a lifetime in cases for most people, and we did it all in about maybe 15 years.
This is in federal court.
Mostly in federal court.
More federal court cases than a lot of attorneys handle.
You got to understand, bankruptcy court can only be in federal.
Right.
Because bankruptcy is not a circuit issue; it's a federal issue. And while there are different laws in different bankruptcy jurisdictions, the law is basically the same because it's a federal law. A federal law is the same in every state. State law does not take superiority over federal law, as you know.
Now, how is it that you were so informed about the law? Is it just through a lot of litigation that you get involved in as a real estate developer and so many contracts that you deal with that you became very familiar with the law?
It's very easy. I became familiar with the law because I went to law school.
And where did you go to law school?
Columbia.
Columbia. Very nice.
New York. I graduated from the University of Florida when it was an all-boys school, a very small university, I must add. There were less than 2,000 students when I entered there in 1944. That's a long time ago. It turned co-ed, actually, in 1949, and that was the only university in the state, University of Florida. The other university was a women's college. It was called Florida State College for Women, which today is FSU.
Wow.
But that also was only women.
I didn't know that.
I'm sure not. Most people don't, but that's a long time ago. And one of the advantages I had in running the Resolution Trust Corporation was to try to put the banking business back on a level footing so that the problems that the banks were facing were eliminated for the banks to face them. We took it over for the federal government. We paid the accounts. They were all insured in those days under the Federal Deposit Insurance Corporation. It's called the FDIC, up to $100,000. Today it's $200,000 per account. But we had a huge amount of authority because none of my employees were federal employees. They were all independent contractors who worked as an employee of the Resolution Trust Corporation. We accomplished a lot in 5 years. We probably wound up spending maybe close to $400 billion. Got back maybe $150 billion in payments. A lot of people made a lot of money on the purchases of the mortgages and or the properties. But the truth of the matter is the ones who made the most were the ones who did the best job, the ones who worked the hardest on the property to get it back into good shape. Many of them had capital with which they were used to finish the job if it was unfinished. And many of them were sophisticated real estate people, although many of them were just new entrepreneurs in the real estate field. And again, the key issue for us was to put the banks back on a sound financial footing, and we did. We closed, as I said, over 1,400 banks. We put a lot of bankers in jail who we found did criminal acts or acts that were not within their authority. And most of that was never even reported in the newspapers, and for whatever reasons, that just wasn't. But when we
now, how does the RTC put them in jail? Through their investigation, then they turned it over.
We had the U.S. Attorney General who actually provided us with the case law. We had our own legal department. As I said, I had over 4,000 attorneys in Washington alone. Who, by the way, an interesting story
RTC wouldn't handle the criminal cases, though, would they? They would turn them over to the federal prosecutors.
Federal prosecutor handled all the criminal cases. When we tried a judge, it was handled either in a circuit court, mostly in circuit court at the local level, because the laws that were broken were state laws. Because compliance with state law was a requirement for a bank regardless. State law was a precedent, whether you're a banker or whether you're a businessman, you followed the law. State law and federal law. Most of the laws that were broken were state laws.
Okay.
So we did prosecute state laws and federal laws. Federal laws through the federal bankruptcy, federal attorney. State law through our attorney. We actually brought the case, filed a motion with the court, circuit court in most cases. Some of them were appealed. We went to appellate court. As you know, there's only 4 courts in Florida, which makes Florida very unique. There's no municipal courts in Florida. We don't have municipalities that have a court jurisdiction. And years and years ago, Florida had a court in every small town you could imagine. You never knew who you were going to see. Some local guy would...
They did that in New Jersey where I lived.
Well, but it was predominant in Florida. Florida's legislation way back maybe 60 years ago, 70 years ago, changed all of that and incorporated a single court system with 4 courts. You have the minimum court, which is the municipal court. You have the circuit court, and you have the appellate court, and you have the Supreme Court. There's no other court. Once the Supreme Court rules, you have no appellate process beyond the Supreme Court unless it's a federal issue. Then, of course, you can go to the U.S. Supreme Court if they'll accept the case.
So when did they stop the municipal courts in Florida?
I would say probably in the early 50s, maybe mid-50s.
And do you know why they stopped them?
Sure, the abuses. People would get 4 tickets driving from Jacksonville or Miami every time you went through a small town and you were going 36 miles an hour in a 35-mile zone.
Right.
Half the town's of financial means came through the court system.
And just look at Miami. You could be going through 50 towns just going through Miami-Dade County.
And that's real. Don't forget, we had no superhighways then. You drove down US 1.
Wow.
US 1, if you even look at it today, is loaded with different municipalities.
Right. Interesting.
So, and the AAA, which is the Automobile Association of America, used to publish the towns that had bad courts or don't speed, you'll get a ticket. And they did. I mean, they actually stopped cars, and you had to wait in line in these courts to adjudicate your ticket.
Well, I hear these stories now about Georgia. You know, don't drive through Georgia. You can't.
That's right. That's right.
Keep you in jail if you don't have your
Again, I must
cash.
tell you, there was no such thing as a superhighway. I-95 was nowhere in anyone's dream. Or any of the interstate roads. That was a federal project done by the states, but funded by the federal government.
We're going to take a break, but before we do, let's get back to law school. Did you go to law school right after college, or was there something in your career? did you go later? Something in your career that motivated you to go to
Yeah,
law school?
I was very young when I went to college. When I graduated from the University of Florida, I graduated as a psychological statistician. I got my bachelor's degree in it. Then I wanted to learn more about the law because of my own frustration with attorneys telling me, well, that's the law, and you got to do it that way. And you know me pretty well now, and I just don't accept people telling me it's the law. So I wanted to find out for myself. I really never had any desire to practice law because I always felt it was less than I wanted to achieve. I could, being a lawyer, you can only make as much money as you can put in the hours.
Certainly less lucrative than
I'm
real
not,
estate
yeah,
developing.
I'm not saying to you that it's not a good profession. It is. It's an admirable profession. And attorneys today make a lot more money. But the truth of the matter, on a 40 or 50-hour week, you can only make what you can charge your client for 40. In those days, a good attorney charged $60 an hour. That was a big fee. Well, today, I don't have to tell you, New York attorneys charge $1,000 an hour, if you can believe it. That's
Right.
really, and you know it. In Florida, $300 to $500 an hour is not an unusual charge.
Right.
And one of the problems with those expensive costs to attorneys, and I'm not knocking the legal profession, is that less and less people can afford it.
Yes.
And therefore, many lawyers go out and try to stimulate cases by saying they'll do contingency work, or they'll take your case regardless of the case on the basis of a percentage of the award. I'm not saying it's the wrong thing to do it. I just say it's a different way to run a courthouse. Courtrooms are different today.
But the problem is that the courthouses are closed, other than to the very wealthy.
That's
I mean, even
true.
with divorces, there's so many people they lose custody of their children because they just don't have the money to pay an hourly fee that it costs. And there's no contingency in divorce. You can't charge a contingency fee. It's ethically prohibited.
Right.
By the Florida bar.
Right, and it should be.
And that's a problem in
It
family
is a
law.
problem. It is a problem. We have a huge number of problems with the judiciary. As you know, I was part of the Judicial Qualifications
Yeah, I'm
Committee.
going to get into that with you
which
later,
is a
too.
different organization. It's an organization I was involved as the chairman of the JQC and then as a member of the JQC for almost 20 years. And, of course, their authority is to fire a judge. Every single judge in the state of Florida, in the Florida Constitution, is liable to charges being brought before them by the Judicial Qualifications Committee, who can then rule that the judge is guilty and cannot serve as a judge anymore the rest of their life in the state of Florida.
Well, we're going to take a quick break,
Okay.
and then we'll have a lot more to ask you about the JQC.